Good afternoon, everyone. I'm Bob Porter. I'm the Vice President of Public Policy at the St. Johns County Chamber, and I am here today with Beth Sweeny, who is the chair of our Public Policy Committee, and Meg Zabijaka, I got it, there we go, who is a partner with Constangy, Brooks, Smith, and Prophete, a premier labor law firm based in Jacksonville, but it's a nationwide law firm. And we're here to hold a chamber conversation on an issue that has gotten quite a bit of press the last couple of weeks, which is the employer vaccine mandate that was originally imposed, but is tied up in courts by the Biden administration at the federal level. And then in the middle of November, the state legislature held a special session to basically do their best to prevent employers from requiring vaccinations for their employees. It's a very complicated subject, but it has, I think, great implications for our chamber members, predominantly, I think, our smaller chamber members. So this is going to be pretty much a show and tell on what the current status of both the federal and the state legislation is, and really what you can expect as employers, what you can do, what you can't do, what you should do, and what you shouldn't do. So with that, I'd like to start with Meg. If you could just give us the current state of play, the current background, kind of how did we get to where we are right now, and what, as you said earlier, 2:05 on a Friday afternoon of December 17th, what the current state of play is for the employer vaccine mandates.
Certainly, and thank you. I'm happy to be here today. So before the Florida legislation was passed, there were 3 vaccine mandates issued by the federal government for various agencies that have the authority to act in this space. One of those was issued by the Occupational Safety and Health Administration. One was issued as applying to federal contractors, and one was issued by CMS, which applied to healthcare employers who receive Medicare or Medicaid funds. Before Wednesday of this week, as Bob mentioned, all 3 of those federal mandates requiring vaccinations, and in some of the mandates, testing as well. They varied on the mandate. Those mandates were stayed by federal courts, meaning that they are not being implemented. There are no enforcement actions taken. Wednesday of this week, however, federal court in Florida and several other federal courts released essentially or raised the injunctions. And so now for the CMS mandate that applies to healthcare employers who receive Medicare and Medicaid funding, there is an injunction against that mandate being enforced in only 25 states. And those states do not include Florida. So we know that the Florida legislation that applies to vaccine mandates is in effect for any private employers in Florida. We believe, and as Bob said, it changes as the wind blows. We believe that the CMS entity will not take enforcement action with respect to that vaccine mandate. And the reason we believe that is on December 2nd, when there was a nationwide injunction issued by one of the courts I mentioned, CMS issued a memo basically saying that while there are any injunctions in place, we are not going to take enforcement action of the vaccine mandate. So at this point, we think it's somewhat safe to assume that Florida employers are only bound by the Florida legislation. But of course, that can all be subject to change. So at this point, we at least feel comfortable saying that as of today, the legislation that would apply to private employers and chamber members would be the Florida legislation.
Meg, can you speak on the HHS rule? Does that apply to any size healthcare provider or employer, or is that the same as the OSHA rule where it only applies to businesses with more than 100 employees?
So for the HHS rule for the healthcare employers, there is not a minimum threshold of employee numbers. It applies to any healthcare employer who receives Medicare or Medicaid funding. There are some exemptions. For example, that mandate is not considered applying to assisted living facilities. So there are many nuances, of course, as you would expect in this area, but the federal contractor as well as the CMS HHS mandate do not depend upon the number of employees that an employer has.
Thank you.
So let me ask a question then. You mentioned that essentially right now, if you're a Florida employer, the primary thing you need to be concerned with is the Florida
Yes.
Legislation. Is my company required under Florida law right now to not mandate vaccinations? How exactly does that process work? If I am say a Florida employer with 10 employees, what does that mean for me?
So regardless of size, and there are some other provisions as a legislation, but we're talking about it for private employers for our purposes today. Regardless of the size of the private employer in Florida, the legislation does not prohibit vaccine mandates, but if an employer has a vaccine mandate and an employee submits an exemption request, then that exemption, if the form that the employee submits is completed, that exemption must be provided, and the employee cannot be required to have the vaccine. There are restrictions and actually prohibitions against an employer terminating an employee if that employee has an exemption approved and refuses to be vaccinated. So it's not a complete prohibition on vaccine mandates, but effectively the exemptions are quite broad and far reaching, so that if an employee request to not be vaccinated for one of those 5 reasons that I can cover, essentially that employee does not need to follow the vaccine mandate. And those exemption reasons include the typical ones we're familiar with as employers, which would be medical or disability or religious-based reasons rather. It also includes a natural immunity to COVID if an employee can prove that he or she had a test that proves that that employee has had COVID recently and may still have antibodies, and there's a form completed by a healthcare provider. There's also an exemption if an employee agrees to submit to periodic testing or agrees to wear employer-provided personal protective equipment. Those last 2 exemptions fall to the employer in terms of the cost. I will mention too that if you go to the Florida Department of Health website and you type in COVID vaccine legislation, Florida Department of Health, there is a link to forms that the Department of Health has prepared. And we recommend using those forms because they've been blessed, so to speak, by the Department of Health. And those forms, if they're submitted and completed as the form request, then you cannot ask any questions of the employee. The exemption must be applied.
All right, great. Thank you for that summary. Can you tell us what is the enforcement mechanism for the Florida laws then? If an employer does not want to allow some of these exemptions, what kind of fines or action could they face?
So the enforcement mechanism really falls to the employee who's affected. The Florida Department of Legal Affairs and the Florida Attorney General's office are the entities that will be pursuing enforcement. So if I, as an employee, believe that I have been denied an exemption request, like the ones I mentioned, or I believe the exemption request has been improperly applied, or if I'm terminated because I refuse the vaccine and am not given an exemption, I, as an employee, can file a complaint. And then the Department of Legal Affairs will conduct an investigation. If that investigation indicates that the employer improperly applied an exemption or denied it, the Department of Legal Affairs will give the employer the chance to cure noncompliance. But the real teeth in the legislation comes if an employee is actually fired for refusal to comply with the vaccine mandate or because we improperly deny an exemption. And in that case, again, if an exemption finds that the employer has violated the statute, a fine must be imposed as the legislation reads. And for employers with less than 100 employees, the fine is not to exceed $10,000 per violation. And for larger employees, employers with 100 or more employees, that fine is not to exceed $50,000. The one thing I'll mention on those significant fines is that there are factors in the statute that the AG's office is to consider in applying a fine and looking at the amount of the fine. So if and when the federal mandates are put back in place and we have employers, the majority of which may be caught in the middle of the federal and state mandates or legislation, we believe that those factors could be applied to consider employers who are in good faith trying to walk the line in the middle and comply with both federal and state requirements. The other thing I'll say that if an employer is found to have wrongfully terminated an employee because of an issue with the vaccine mandate, the Attorney General's office can offer the employer to cure that non-compliance as well by reinstating the employee with back pay. If that doesn't happen, then you're off to the races as to the fine and the challenges there.
Okay, great. That's some really good information. Thank you.
Meg, when does all of this become effective for Florida employers?
The Florida legislation was effective on the date that it was signed by the governor. And so it was effective November 18th of this year. In the text of the legislation, there was language that the Department of Health was going to engage in rulemaking and provide some regulations within 15 days. We have not seen those regulations yet. There have been some minor wording clarifications that were issued the same day that the legislation was signed, but we are expecting some additional guidance, or we're hoping for it at sometime in the near future.
So that would effectively mean that, I mean, the enforcement mechanism, while it is on the books and they're allowed to do it, there probably won't be any actual enforcement against employers until they know what it is that they're supposed to do.
Well, I think I like your optimism, but I think that the language of the legislation is clear enough that employers can be expected to go ahead and comply with what's written. There are things like, for example, the legislation defines an exemption for medical reasons, including an anticipated pregnancy. That is supposed to be defined by regulation. Also, a definition of the functional equivalent of termination. So the employer violates the legislation if it terminates an employee in violation of the legislation or conducts the functional equivalent of termination. So that's another phrase where we need guidance from the rulemaking. That's what we're waiting on, but I would say that I think it's clear enough now. I would not suggest that employers in Florida wait for that rulemaking because the law was effective as of November 18th.
So if you're a Florida employer right now, you need to follow the Florida law pending something happening down the road with either the federal courts or the Florida law. In other words, the Florida law is currently effective, and you cannot require your employees to be vaccinated unless they provide you one of those five alternatives, wearing mask, that type of thing, getting tested.
You can require the employees to be vaccinated, but if they submit one of those five exemption requests, as an employer, you need to provide the exemption in Florida. There's very little leeway there. And also tread very carefully if you have an employee who you are going to terminate, and if it could in any way have anything to do with the vaccine mandate. As we mentioned earlier, there are some pretty stiff penalties. So Florida employers in the private sector should not be terminating employees because they requested an exemption and we don't want to provide it, or they refuse to be vaccinated.
Okay, well, I'll tell you what, this has been a great eye-opener for me. I thank you for shedding some light on which is obviously a very fluid situation. We at the Chamber will stay on top of this and we'll stay in touch with you as it progresses through the court system so that ultimately, hopefully sooner rather than later, we'll be able to tell our Florida Chamber member employers what they can and what they can't do, or what they should and what they shouldn't do. But right now, follow the Florida law because they can come after you for unlawful termination or one of the other things. So with that, Meg and Beth, thank you so much. Please, as always, if you have any questions or comments, you can send us a note or call us at the Chamber. Again, I'm Bob Porter. I'm the Vice President of Public Policy at the Chamber. My email address is bob.porter@sjcchamber.com. Please feel free to send me any of your questions or comments. Thank you very much, you two. I appreciate it.
And if I can just ask Meg, if you have any resources you want to share with the business community too, or if there's any web pages you can direct our businesses to with additional information about the mandates or how to stay up to date on the federal regulations. I don't know if you have any of that you want to share with us.
Certainly. So the best resource would be our website, which is www.constangy.com, and that's spelled CONSTANGY. There's a link to COVID resources, and we have an employment law blog in particular that's written by Robin Shea, one of our partners in North Carolina, where her tagline is "No legalese spoken here." And so she really tries to boil this confusing area, conflicting area down and sum up where we are with things very well. So I would refer everyone to our website. If there are specific questions that you have that aren't answered on the website, you can reach me through Bob, but we have a plethora of resources on the website that we think could be very helpful. Thank you for asking.
I know I've looked at them and they are very helpful. So
great, thank you.
And thank you, Bob.
Very good. Thank you, Beth. And thank you, Meg. Appreciate it.
Thank you so much.